Hey everybody, Pink Camera Magic here, and welcome to my channel. Today I'm going to go over the final decision in my Cook County arrest case. Now, the district judge for the federal court case is John Robert Blakey. He's the one who made this decision. So I want to go for all the details, and if you have any additional questions or anything like that, or you want to get in contact with me, I'm going to have my email in the description of this video, so you can go ahead and check that out. So I'm going to go over this and we'll go over a few different points here. There's a lot of different areas that people had a lot of questions and stuff like that. So we're going to go ahead and check this out here. So first, it talks about the opinion and the order and just gives some basic facts. Plaintiff Amanda Bergquist, a self-described First Amendment auditor, went to the Bridgeview Courthouse. Now, remember this place, guys. I went to the Bridgeview Courthouse. Cook County has a lot of different courthouses, and the Bridgeview Courthouse is the one that I was at. It's the district that was over by my house at the time. In March of 2018 to address 3 traffic tickets. I went there for 3 traffic tickets. I wasn't going there to do an audit, actually. At the security checkpoints, court security officers told her that she could not bring her video camera that she carried into the courthouse. Plaintiff subsequently began filming the exterior of the courthouse, scanning up and down with her camera. When officers noticed, they confronted her, asked her for her identification, and attempted to ascertain her intentions for filming. Plaintiff refused to identify herself, remained uncooperative. So first, they're going to talk about my initial contact with Barbero. The Bridgeview, remember again, the Bridgeview Courthouse in Bridgeview, Illinois handles a variety of cases, including traffic, domestic violence, felony matters, victim witnesses, jurors. They all use the front entrance. On March 28th, I went to the Bridgeview Courthouse to address 3 traffic tickets. I carried with me a Sony handheld camera in my purse. At the time, I went to try to go through the checkpoint. They wouldn't let me go through it, but suggested that I contact the sheriff's office to see if they'll hold it for me while I go to court. I went outside because they wouldn't let me in with it. It was in my purse. I contacted the sheriff's department. They said they will not let me, they would not hold it for me. So I was outside trying to think of what next to do before I go to court. Plaintiff then stood outside the front entrance of the Bridgeview Courthouse and began filming. Plaintiff asserts that she was recording her reflection in the mirrored windows surrounding the building and the no smoking sign. While the defendant maintains that plaintiff's recordings captured activities both inside and outside the courthouse, including various people entering and exiting the courthouse, the entryways, security features, including the positioning of the security personnel, locations of metal detectors, surveillance cameras, emergency exits, panic buttons, call boxes, and vehicular barriers. Okay. I don't know about you, but you saw the video, right? And I'm just to refresh your memory, or in case you haven't seen it, let me go ahead and just show you all these things that I apparently recording beginning. So okay, so I go and look. Now look, you guys, that's a mirror right there. Okay, I can see my reflection. You cannot see inside beyond that point from where I'm standing. I don't know. Maybe you see something that I don't see, or maybe you see the same thing that they saw, what they claimed that I saw and was recording. So I was a good distance away, maybe a good 10, 20 feet away. And what I was doing, because I usually use a cell phone, not that it matters at all. But what I was doing was I was panning, I was practicing my shots because the camcorder was relatively new to me and I don't use it very often. So I was doing some practice panning, stuff like that. And I was fully intending on doing an audit, fully intending. So I'm not trying to not deny that. But at the time, I was being very truthful when I was saying that I wasn't recording people, I wasn't recording security, I wasn't doing all the typical auditor things where you go up and you're recording the cameras and you're going in people's faces, stuff like that. I literally was not doing any of that. I was panning and I was recording my reflection there. So let's take a look here. All right. This is as close to inside as I recorded. That's it. Okay. You can see where it says visitor there, but the security checkpoints, all that, the stuff that they mentioned, you can't see any of that. And I wasn't trying to look for it. I was focusing on him because he answered the door or opened the door and called for me. I answered his questions until then. Okay, you could see people kind of coming and going, but I obviously now here. Oh, and also I was trying to get his name tag, but obviously I wasn't recording people. Okay, So let's get that straight. All right. Okay. Officer Barbaro, a sheriff's deputy working security that day, testified at his deposition that he saw a woman outside the building videotaping the building, scanning back and forth with the camera up and down, people coming in and out, possibly. Okay. Possibly videotaping through the glass at the security post that I work at of entry procedures. Officer Barbaro came out, stood at the front entrance with the door propped open. By his body, asked plaintiff what she was doing. You guys saw what happened in this. It's just kind of a rundown. And it says right here, plaintiff's video shows the interior of the courthouse entrance. Well, I mean, you be the judge. I don't know if I was, if it looks like I was trying to record inside or if it was just because I was recording Barbaro because he stood out at the door. So, anyways, moving on. According to defendant Dorsak, who worked security that morning, somebody standing at plaintiff's distance to the courthouse would be able to see inside and videotape inside the building. I don't know. I guess he saw something that maybe I didn't see. What do you think? You guys saw. Where the plaintiff was standing, the front door security is laid out, including security equipment and the x ray machines. I didn't see an x ray machine. Did you guys see an x ray machine? Let me know in the comments. Okay, now they're going to talk about my encounter with Malazzo. Barbaro radioed for additional security and requested a supervisor response. Defendant Malazzo then responded almost immediately by coming to the scene. That was fast, by the way. That was really fast. Officer Barbaro said to Malazzo that the woman is taping the building. I asked her why. She said because she wants to. At his deposition, Malazzo testified that at the time we didn't know if she was videotaping people coming out, videotaping witnesses, videotaping people that were involved in domestic violence, videotaping people inside the door where the security posts were. Malazzo found it suspicious that she was videotaping the building and possibly inside the doors. Of course, he was suspicious and he grabbed my camera and deleted all the footage in the camera, deleted evidence, basically destroying the evidence of my crime. But we'll get to that in a minute. Malazzo approached plaintiff and told her that there exists a judicial order that says that you cannot tape this building. Plaintiff then asked Malazzo if she could see that judicial order. Malazzo said, yeah, come on in, and we're going to check your IDs too. When the plaintiff said, oh, you're not going to, and Malazzo said, no, 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 we're going to run you, and we're going to get your name, and we're going to do a report. Y'all know that part that went down. Okay. Plaintiff refused. No. Nice quote. After which Malazzo informed her that he was detaining her and that she was doing something suspicious. Malazzo asked her to come in. Again, plaintiff responded, I'm just going to sit right here and continue recording. Malazzo repeated, you're going to come in and we're going to find out who you are and what you're doing here. And I said, no, you're not. At that point, Malazzo turned to the front door of the courthouse, asked who's got cuffs. She doesn't want to go agreeably. So this is just kind of a rundown of what happened that you all know from seeing the video. Asked if he was familiar with the First Amendment. He grabbed my camera and put me in handcuffs and brought me inside of the courthouse. All right. After being escorted inside, defendants Malazzo and Larson made multiple requests for plaintiff to identify herself, and both informed her that she could go if she identified herself. I love how they do the breakdown, how they do it, making the officers seem a lot more favorable and not pointing out the obvious like infringement on my rights. It's mind blowing to me. Anyways, I'm gonna try to stop interrupting myself. Malazzo also stated that he would detain plaintiff until he could decide who she was. Plaintiff expressed her desire to remain silent, and I requested a lawyer at that time. I refused. She refused to consent to searches and seizures of her camera and asked Malazzo if he'd heard of the Fourth Amendment. After the statement, the video footage from plaintiff video ends. Malazzo testified that while plaintiff remained detained, he contacted his supervisor, defendant Jackson, who instructed him to contact the presiding judge's office for further instruction regarding the plaintiff. According to Malazzo, he called the presiding judge's office, and an assistant told him to bring the plaintiff to Judge Peter Felice. At some point during plaintiff's detention, Malazzo emptied the contents of plaintiff's purse on the counter and searched her wallet until he found her identification. Malazzo also searched through the contents of plaintiff's camera. The parties dispute exactly how long plaintiff remained detained. Plaintiff states that she was in the deputy's office for an hour and a half, handcuffed, and the defendants dispute the statement but could not offer an estimated time of detention on their own. Not once did they say I was arrested, so that's important to know. Plaintiff's court appearance. Okay. So this is kind of what this is basically is a breakdown of what happened in court. For those of you who don't know, I'm obviously going to have everything linked in the description, but basically I went in front of Judge Peter Felice. He wanted to know what was going on. Milazzo told him that I had basically was videotaping outside, and um, he was concerned about what I was videotaping. And so then the judge asked me directly, what am I doing this for? He said, why are you recording people coming in and out? I said, that's not true. I wasn't. And then he just like interrupted me. Well, there is people walking in and out, isn't there? He's very, very sarcastic and very just pompous, you know. So at the end of the day, what ended up happening in the court appearance was with no due process, no attorney by my side, nothing like that. The judge demanded that I destroy the video footage. But Donald Milazzo had already grabbed my camera at that point and deleted all the stuff that was in there. I actually saw him delete it, and you could hear it, and it's actually captured on the dash cam, or excuse me, on the body cam footage.
Okay.
Did you delete my footage?
Do you want to cooperate or not?
I'm remaining silent. So that'll also be linked in the description. But he actually deletes all my stuff. So then the judge was like, basically like, he wants everything destroyed. He took my SD card, want to know if I wanted it back. I said, yes, I definitely do. So I was set up to come back in a couple days to get that. And I did. And when I went to go pick it up, the judge handed it right to me, said, we didn't look at anything. We didn't delete anything. Have a great day. My assumption is that maybe he talked to somebody to get some guidance on what to do himself or what should be done. And somebody told him, that's not a good idea. Like, you shouldn't be doing that. Anyways, I'm no lawyer, obviously. So that's just what I gathered happened. Because I don't think he just decided to come to his senses. Anyways, Judge Felice informed me that there's a standing court. Okay. Judge Peter Felice then informed plaintiff that there is a standing court order that no photography is to take place inside the courtroom, and that's going to include the entrance and the exits. He also instructed me not to record this building, people coming and going out, anybody in the parking lot. He said, and I asked him just to make absolute certain, I asked him, is it okay if I record from the sidewalk? And he said, no, you can't record anywhere and I'll be in contempt. This is going to blow your mind, you guys. Okay. So there's this judicial order about recording in the courtroom, courthouse, and okay, in and around the courthouse. I'm going to show you that general order, and this is going to blow your mind. Okay. So right here, this is the general order, 2013-05 regarding cell phones and other electronic devices. Okay, this is what they're referring to. Okay, this was done in 2013. Okay, it is hereby ordered, except as noted below, that all mobile computing and telecommunication devices, including but not limited to cellular telephones, smartphones, laptops, etc., things that can record or stream to the internet, anything for making audio, video recording, they are prohibited in the George N. Leighton Criminal Courthouse at 2600 South California Street in Chicago, Illinois. Okay. I was at the Bridgeview Courthouse where this administrative order does not apply. But I didn't know about this before I recorded, so I couldn't say anything about it at the time. But Lieutenant Milazzo didn't know about it. The judge Peter Felice did not know about it. Okay, he's throwing these directives, and so all of this is based off of a general administrative order or judicial order for a completely different courthouse. Okay. And that's important to know too. Now, the courthouse that they're referring to, they did that because they were worried about like witness tampering and things like that. That's like the big main courthouse in Chicago, right? Chicago's got a number of courthouses, but this is the one where like R. Kelly had his trial. This is the one that Jesse Smollett, where he had his court stuff. And so it's one of the bigger courthouses, right? Mine was just like a little suburban one where this does not apply. The whole time, this judicial order did not even apply to the courthouse that I was in. But nobody seemed to know that, even the judges. So yeah, I'm gonna have all these links in the description if you guys, who are really into the case can check it out. Okay, so we're going to go down a little bit further here. Plaintiff claims and procedural history. So I sued alleging that my operative second amended complaint, 10 claims. Okay, so originally sued him for 10 claims. A number of them had been just dropped automatically by the judge. Let me see here. So first one was detaining. um, for being detained. Okay. Yes, they have to have some kind of articulatable suspicion to detain someone. I wasn't really tripping so much off the detainment. I think it's just my attorney was just adding stuff on there. But I understand that the bar is extremely low for detainment. Like for any reasonable suspicion could be anything. They could say, hey, we reasonably thought that you were breaking this judicial order. And that would be legit, right? So what I would have done differently, and I think I did it for the most part, but what I would have done differently is right from the beginning, I would have, when they asked me why I was recording, I would have said, there's a reason why it's so cookie cutter to be like, I'm creating content, I'm gathering content for a story, you know, re- exercising my First Amendment right. You gotta say that. And plus, when you decide that you want to remain silent instead of just saying remain silent, you got to invoke your Fifth Amendment rights. You have to actually verbally say that, hey, I'm invoking my Fifth Amendment rights, so it's clear, right? You can't just say I'm going to shut up now. Then they could still use it against you. So, anyways, let's go back to this. Okay, so yeah, they dropped a number of the charges that we did. Summary judgment, basically, we both did like a cross summary judgment. The parties cross moved for summary judgment on all of plaintiffs' remaining claims against the remaining defendants. This court addresses each category of claims below. My Fourth Amendment claim. Defendants move for summary judgment on plaintiff's Fourth Amendment complaint, arguing that the record fails to raise a triable issue of fact to the reasonableness of their trial. Of their initial Terry stop and subsequent search of my purse and camera. Plaintiff cross moves for summary judgment on her Fourth Amendment claims, countering that the defendants lacked reasonable suspicion to conduct the Terry stop, that the Terry stop ripened into an arrest unsupported by probable cause, and that Milazzo conducted an unconstitutional search of her belongings. Okay. So plaintiff's initial stop. The court proceeds chronologically, starting with the initial stop of plaintiff as she filmed the courthouse from the outside. On this issue, plaintiff argues that Barbaro's initial stop of her violated her Fourth Amendment right to be free from detention absent reasonable suspicion. Okay, I'm confused. I think there's a lot of sloppiness in this because Barbaro never detained me. If you recall, he just went to the door, asked me what I was doing, and called for a supervisor. That's it. That's all he did. So I don't know if this is just eh, they're being sloppy. I don't know. But anyways, okay, this court proceeds chronologically, starting with the initial stop of the plaintiff as she filmed the courthouse from the outside. On this issue, plaintiff argues that Barbara's initial stop of her violated her Fourth Amendment right to be free from detention, absent reasonable suspicion. While defendants argue that Barbaro possessed reasonable suspicion to conduct a Terry stop, he didn't do a Terry stop. So I'm hella confused by that. Anyways, given the factual record, defendant's theory prevails. Clearly, videotaping other people when accompanied with other suspicious circumstances may constitute disorderly conduct under an Illinois statute stating that a person commits disorderly conduct when they knowingly do any act in such unreasonable manner as to alarm, disturb another, or provoke a breach of the peace. Okay, you all saw the video. It, do you think what I was doing would be disorderly conduct? If I would have said who I was, would that be disorderly conduct? I don't know. Let me know in the comments. In this case, Officer Barbaro testified that he observed plaintiff scanning back and forth with the camera, up and down, people coming and going out, possibly videotaping through the glass at the security post that I worked at and the entrance procedures. Okay. By this logic, I could see somebody walking down the street and say, well, he's possibly going to rob a store. I don't know what his intentions are walking down the street. There's a store right there. He could be walking down the store and he didn't tell me who he is, so he might be robbing that store. I don't know. Seems legit, right? Okay. All right. Disorderly conduct when they knowingly do any act in such unreasonable manner as to alarm, disturb another, and to provoke a breach of the peace. In this case, Officer Barbaro testified that he observed the plaintiff scanning back and forth with the camera up and down, people coming in and out, possibly videotaping through the glass at security posts, blah, blah, blah. According to Officer Barbaro, the courthouse installed cameras outside the building after 9/11 attacks to watch the intake of the air system in case somebody wants to do something with that. Given such circumstances, Officer Barbaro had reasonable suspicion to believe that plaintiff violated or was violating a general administrative order of the court. Based off based off of that, okay. The parties also disagree whether Barbaro's radioing of Milazzo and then Milazzo's subsequent questioning and detention of plaintiff outside and inside the courthouse amounted to an unconstitutional Fourth Amendment seizure. On this issue, plaintiff contends that once Milazzo handcuffed and led her into the courthouse, the action escalated the initial Terry stop into a de facto arrest, which she argues was unsupported by probable cause. Defendants, on the other hand, maintain that plaintiff's continued detention remained within the scope of permissible Terry stop and did not ripen into an arrest. Okay, it it did not ripen to an arrest, but you still searched my items. Okay. This view find this view finds support in the record because plaintiff's evasiveness and refusal to identify herself prolonged the initial stop. The Supreme Court has explained that obtaining a suspect's name in the course of a Terry stop serves important government interest, blah blah blah. But, what if somebody wants to be secure in their persons? And I don't know. But anyways, it's talking about all the why it's good to give your name, but so, because the whole point of the investigatory stop, as the name suggested, is to allow police to investigate, in this case, to make sure that they have the right person. Yeah, I was the one recording because they literally took my camera out of my hand. So, yeah, that was not a question. What it was they were holding me because they wanted to get my name. They weren't investigating anything because they literally told me that all I needed to know was who I was, and they could send me on my way. They weren't investigating like whether or not I went in the fucking ductwork. They weren't investigating if I was a potential terrorist. They were only doing that because they wanted to get my name. Anyways, while relevant facts remain in dispute regarding the scope of the detention, such factual questions remain irrelevant here because even if the initial stop ripened into an arrest, the officers possessed probable cause, explaining that the same events supporting officers' reasonable suspicion to conduct a Terry stop also supported their probable cause to arrest. Based upon the record, a reasonable officer had probable cause to believe that the plaintiff violated the general administrative order prohibiting filming inside the courthouse. That does not apply to that building, and I wish I would have known about it, and I wish I'd known at the time because I could have said something to them, but yeah, okay. So that's what the probable cause was based off of. So they had probable cause to believe that I was recording inside the courthouse over on California Avenue, apparently. So, anyways, okay. So, based upon the record, a reasonable officer had probable cause to believe that plaintiff violated the general administrative order prohibiting filming inside the courthouse, as well as the Illinois statute prohibiting disorderly conduct. Moreover, by the time Milazzo ordered the other officers to handcuff plaintiff, the officer's initial observations combined with plaintiff's evasive answers to routine questions about her identity and intentions, um, given the totality of facts available to the officers who viewed plaintiff's behavior as well as her own evasiveness and lack of cooperation, a reasonable, prudent person in the officer's position would think that the plaintiff had committed or was committing a crime. If the officer had probable cause to believe that an individual had committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender. Okay, the other officers, they didn't know what the fuck I did. They actually were just doing whatever their lieutenant said to do. So that's stupid. Anyways, accordingly, this court finds that reasonable suspicion justified plaintiff's initial stop and that probable cause supported her later arrest. Okay. Qualified immunity as to the seizure. Even if plaintiff could raise a triable issue of fact as to whether the officers possessed reasonable suspicion to conduct the Terry stop or alternatively probable cause to continue to detain her, the doctrine of qualified immunity would also doom her Fourth Amendment seizure claim. The doctrine of qualified immunity balances dueling interests, allowing officials to perform their duties reasonably without fear of liability on the one hand, and affording members of the public the ability to vindicate constitutional violations by government officials who abuse their office on the other. So this basically talks about qualified immunity. So they, destroyed my Fourth Amendment claim, which was the big one, based off of the probable cause and reasonable suspicion and the qualified immunity. So there you have it. That's what the judge was thinking. The court concludes that qualified immunity forecloses plaintiff's unconstitutional seizures claim. In this case, the relevant questions are whether plaintiff demonstrated that, in light of precedent existing as of March 2018, defendants were plainly incompetent or knowingly violated the law when, after they viewed plaintiffs recording the exterior and interior of the courthouse, engaged in a Terry stop to ascertain her identity and intentions, and arrested plaintiff after she refused to identify herself and continued to record both the exterior and interior of the courthouse. Plaintiff had not met this burden because she has pointed to no clear precedent that prohibited the officers from detaining her under these circumstances. Instead, plaintiff argues that it was clearly established in March 2018 that officers could not detain or arrest a person for exercising her First Amendment rights in filming on a public sidewalk outside of a courthouse. To be sure, no one questions that the act of making audio or audiovisual recording is included within the First Amendment guarantee of speech and press rights as a corollary, whatever, of the right to disseminate the resulting recording. But this defines the clearly established right as a high level of generality without considering the specific context of the case. All right, so it kind of talks about that a little bit. Okay, I'm going to go down. I'm not going to just like read everything. I'm going to just kind of break down just little bits and pieces here. Searches of my belongings. The court separately analyzes plaintiff's claim based upon the constitutionality of the officer's searches of her purse and the contents of her camera. The undisputed records show that at some point while the officers the undisputed record shows that at some point while the officers held plaintiff inside the courthouse, Milazzo emptied the contents of plaintiff's purse on the counter and searched her wallet until he found her identification. Milazzo also searched through the contents of plaintiff's camera. Plaintiff challenges the constitutionality of these searches. Warrantless searches are per se unreasonable under the Fourth Amendment unless they fall within a few specifically established and well delineated exceptions. One such exception allows officers during a Terry stop to frisk a detained person for weapons. They're talking about Terry stops there, where a warrant isn't, required. Justification for this exception is the protection of the arresting officers. Okay, of course. And then applying these standards, the seizure and search of plaintiff's purse and wallet plainly fall within the scope of the search incident to arrest exception because plaintiff exercised immediate control over her purse. Basically saying because I held it on me, like if you get arrested and you have a bag on you, they can search your bag. I mean, I guess a purse is a bag, but let me see what example they use here. Like, okay, they search they're searching a car and there's a bag in the car. They can search the bag that's in the car, basically because it's something that's close by. Okay, and then another thing too, they also quote a different, like when they're talking about like my camera, they quote some different lawsuits. Looks like Raleigh versus California. So when you arrest somebody, like it says a warrantless search of a cell phone is not permissible search incident to arrest. But the reason they say that is because your cell phone holds a lot of personal information. A lot of people do things on their cell phone. They, so let's say they're looking for pictures on your cell phone. There's a lot of other things that are open to seeing then. So they would need a warrant for that. But what they're trying to say is with a camera, they don't need a warrant because they don't expect any other things other than pictures on there. So you're able to go and just basically find what you're looking for without being too invasive, I guess, or too intrusive. However, there are no current like case law to say that that's established that you can't look through people's cameras, that it would be a violation of the Fourth. Like that hasn't been tested yet, or established. So that's what they're trying to say here. So in this case, the court need not conclusively determine whether the court's holding applies to cameras because defendants are entitled to qualified immunity on the warrantless search of plaintiff's camera. To overcome defendant's assertion to a qualified immunity defense, plaintiff must demonstrate that existing precedents clearly established that the warrantless search of a camera incident to an arrest was unconstitutional, which there is not. So there's that. First Amendment retaliation claim. In counts 1 and 2, plaintiff alleges that defendants arrested her in retaliation for her protected First Amendment activity of filming. The parties now cross move for summary judgment on these claims. Plaintiff argues that the undisputed facts establish the defendants retaliated against her for engaging in First Amendment conduct, while defendants argue that qualified immunity entitles them to summary judgment. To prevail in her First Amendment retaliation claim, plaintiff must prove three elements. One, I'm engaged in activity protected by the First Amendment. Two, that I suffered an adverse action that would likely deter future First Amendment activities, which they took my camera and took me away from that situation. So I would say so. But again, I'm not a lawyer. The First Amendment activity was at least a motivating factor in the defendant's decision to retaliate. I would think so because if I was standing there without a camera, I don't think they would do the same thing. So that's just my opinion, though. And obviously, my opinion don't matter in my case. The Supreme Court held that in most cases, probable cause to arrest defeats a claim of retaliatory arrest. Yeah, that's bizarre. Because of the fact that I'm arrested, it defeats a claim of retaliatory arrest. I don't understand really what this means. So if you can, if anyone who knows could explain to me, I would appreciate that. So there was probable cause to support a warrantless arrest. So because of that, it means that they can't do a retaliatory claim because they have probable cause, which they thought they did, but they didn't. But whatever. A Monell claim. I'm not going to really get into this too much either. It's just so they're basically knocking everything down one thing at a time. So all of my claims were dropped, and theirs were dropped against them as well. So I did not win. For the reasons explained above, the court grants defendant's motion for summary judgment and denies plaintiff's motion for summary judgment and directs the clerk to enter judgment in defendant's favor of all remaining courts. Blah blah blah. So okay, so yeah, so there's a lot of things, and there's also a lot of things that I wanted to add to this as well. There's a lot of bits and pieces to this that that are a part of this as well. I'm not sure if those of you who've been keeping up with me, about 2 months prior to my arrest here, or actually like a month prior to my arrest here, myself and Chi-Town Sue were arrested also in Cook County for recording at the post office. And I just reposted that video. I remastered it and I put it on my channel. Um, excuse me. And we were arrested there, and it's the same courthouse, same people, same judges, all of that. And while I was there, they kept violating me. This is when both of these cases were going pretty much simultaneously, and the video came out. And when I would go to court, a lot of times, and sue, they were like, the judge was openly saying, "You guys are those people who record all the time, and you guys shouldn't be recording. You know, I don't know why you're recording, and that's stupid." Like they were saying stuff like that. Even my public pretender would come to me and say you're not supposed to record, like it's telling me it was illegal to record them. And I'm just like, have you lost your mind? You know, it blew me away. It blew me away. So I had to get a different lawyer. And also, additionally, toward the end, with my attorney, he actually ended up transferring and not transferring, excuse me. He ended up joining a different law firm that took over my case. So I had to re-sign paperwork and everything. It was from called Johnson Law. And so when the relevant important parts of my case were coming up, my I think a lot of my representation got really sloppy, and there's a lot of stuff that was sort of lost in the mix. Like I didn't know if Solomon was still representing me. I didn't know if Ven Johnson was representing me. Like there was a lot of stuff. And so I think that a lot of the small details, like the fact that the judicial order does not apply to that courthouse, all these things that could have really made a huge difference in my case did not. And at the end of the day, my honest opinion, and might be kind of tacky to talk about, but at this point, I really don't care. I probably shouldn't have released the depositions either, but I just don't care. Um, things got really sloppy. Okay. And to be honest, I think that the only reason that we even appealed is because, I mean, I certainly wanted to appeal and I wanted to go the whole way and I wanted to do a jury trial, the whole 9 yards. But I think that my attorney, between the move and all these other things and stuff being sort of lost in the shuffle, wanted to just recoup the lost money because I was on a contingency where they didn't get paid unless I did. And so with them dropping the case, they weren't getting paid. So it was like he just wanted to get enough to cover their costs and then call it a day. Because Ven Johnson, I know the new attorney did not want to take these cases. A lot of stuff was lost in the shuffle. I don't know if y'all remember, but I was arrested in Leon Valley for recording outside. They arrested me for holding a sign that said "fuck the police." And he was supposed to represent me there too. And then it kept prolonging, and they kept not filing until I finally got in contact with them, and they decided not to do it like at the last minute. And then the statute of limitations ran out. Like it was a mess. Like there's a lot of sloppiness at the end. So Um, to continue forward and to go on and take it to like the next level of court and stuff like that, it's very expensive and very time consuming. And I just don't have the means to do that. I never did. So I don't know. It's just it's hard. I would love to have taken it further. And in fact, if any of you guys happen to know of something that I could do still if it's not too late, I don't know if anything what my next move would be, but that in my opinion is why, like, because at the end of the day though, it's not about getting money. I really don't care so much about getting like a settlement. I would much rather have these guys be accountable. They treated me bad. I mean, you saw how bad the video was, but everything else beyond that was like way worse. And I'm so glad that I was able to share those depositions with you because ultimately, I mean, the court of public opinion is very important. And I have no chance at going up against Cook County. All these judges, they work together. It's Chicago and Cook County pretty much they gave birth to the good old boys club. I mean, they're so deep rooted in the corruption. I mean, it goes back so far, and I don't have a shot when it comes to these guys. And I love to expose these things, and I love for you guys to see them so that we all know we're the ones who have to entrust ourselves with, and we give them this power to like make arrests and do things like that, and we got to see what they're really like. And all this the stuff with at the court, the way that they treated me beyond that, these depositions and how ridiculous they are, like all this stuff is it's for you to see. And that's why I do what I do. So anyways, I feel like it's a success. That was my Chikari Richardson moment, I think, was releasing the depositions. So yeah, so there it is, guys. I know a lot of you had questions about how it all turned out, and at the end of the day, I still think it turned out well, and certainly could have turned out better, but that's okay as well. So, anyways, I appreciate you all. Thanks for watching. As I said, everything's gonna be linked in the description below, guys. Take care.